Now, the purpose of this discussion this evening, from my perspective, is to canvass a range of topics and to provide some general information as to the workings of the court, so as to assist you should you find yourself in the unfortunate position of having to come and see me. Hopefully it's not that scary an experience if indeed it does happen. I indicated to Donna in the discussions in the lead up to this that I'm perfectly happy to take questions. Frankly, I have no difficulty at all with people raising matters of interest as we go, noting, of course, that we have a finite amount of time and that, you know, those sorts of questions may end up with us being derailed from the intent of my speech, which is probably not a bad thing. But the relevant point is feel free to stick up your hand and ask a question if I say something that, you know, triggers a point of interest in your mind. I will add on that I think the material which might have been circulated indicated that there were some limits to that which I can discuss. Regrettably, of course, I can't touch on matters that are before me in court. So if there's a matter that's before me in open court that I haven't made a decision about yet, then that's not appropriate for me to make a comment about that matter. If you do ask me a question about the nature of something like that, I'll just tell you that's not a question I can answer. Right. In relation to, or moving forward, I'll just add a few things before we move to the substance of the discussion about myself. Donna indicated, obviously, I'm one of the full-time mining wardens in Western Australia. I say full-time as all magistrates consider wardens. So when you're commissioned as a magistrate, you are also commissioned as a mining warden as well. And so all of the magistrates who sit in Western Australia have the capacity to sit as mining wardens, but at the moment, only 2 of us do. As had been indicated, I was appointed as the Perth Field Warden in late 2021, which followed my appointment as a magistrate. It's relevant to say, I think, in the context of some of the other things that I'll say during the course of this evening, that by way of background, prior to coming to the court, my position, or the position that I held, was with ASIC. I was Special Counsel Criminal Law at ASIC, with responsibility for the strategic oversight and guidance of white-collar crime investigations in Western Australia, or in Australia at large. Obviously, interestingly enough, you know, that experience serves me well in respect of some of the individuals with whom I spend time with in the court that I'm now responsible for. I've also spent time, as indicated, working as a government solicitor, so I have a pretty detailed understanding of how government works in general terms. And before that, I was in fact posted overseas in Papua New Guinea as an advisor with the aid program there, working with the Office of Public Prosecutor on complex white-collar fraud. Now, the reason I raise that is that it gives me a reasonably unique background within the magistracy of exposure to complex litigation. Now, for those who have been fortunate enough during the course of your careers to avoid any kind of litigation, I say well done to you, good job. But there is litigation and then there's complex litigation. Now, the litigation that occurs in the Wardens Court tends to be the latter. It tends to be reasonably complex and it tends to be quite difficult. It's quite nuanced. And of course, it involves significantly moneyed and resourced people who tend to fight with vigour in relation to defending their interests and their rights. And the reason why I raise it is to say, in the past, and this is relevant to my discussion about the way that the Wardens Court was structured in the past and where it's moving to now, is in the past, wardens consisted of magistrates who were largely criminal lawyers who'd been sort of sent into purgatory to stay in the Wardens Court. Now, when I was appointed, the Chief Magistrate said to me, can you go and be the warden? And because I'm a very compliant sort of guy, I said, absolutely, sir, I'm just happy to be here. I'll do whatever you want. But I do have a background in complex litigation, which serves me well in the context of the work that I have to undertake. Because whilst it is a specialist jurisdiction and there is specialist language that is used, and at first blush you look at it and you think, I have no idea what this is about, it's actually really just complex civil litigation with some slightly different language. And it's relevant because one of the things that's happening now, I'll talk about my former colleague, Warden Cleary, in due course, but one of the things that's happening now is we're looking for a replacement for her honour. And one of the things that we're doing is reaching beyond the usual pool of people who might be appointed as magistrates to find someone who's specifically suited to the work of the Wardens Court, which I think is quite a big deal in the context of what's gone before. Now, as I've indicated, I believe in the rule of law, And I have to say that again, because I am going to say some things that might be regarded as moderately controversial during the course of this particular presentation. And I want to be clear in explaining to you the underpinning of why I say what I say. In relation to the nature of my position, I'm a judicial officer. I'm a commissioned judicial officer. I'm independent of government. And I have a series of obligations which exist that sit above any notions of government policy or anything like that. And that notion of independence is central to the rule of law, as I will explain in due course. And it is something that I believe in with an almost religious fervour, in the sense that it is the guiding tenet of all those who work as judicial officers to act in an independent, impartial and fair way. Now, as the warden, and this is one of the common misconceptions that I encounter, people say, well, what do you think the law should be? I have no view as to what the law should be. It's not a matter of concern to me what the law actually is. It's not my responsibility to decide what the law should be. It's my responsibility to apply the law as it's written. And there's a very serious and important distinction to be drawn in respect of all of the discussion that we have, is that I don't make the law. The law is made by Parliament and set by Parliament. And all of you, no doubt, will remember your civics lessons about the nature of the separation of powers, and I'll discuss that in a bit more detail as we go on. Now, in relation to, in general terms, there's a relevant question of why did I want to speak to you? Well, I've mentioned to you already in my introductory remarks that I believe in the concept of the rule of law and I believe in the transparency of decision-making. In order to explain a bit further as to why I took the opportunity to speak to you this evening, I am going to expand on those topics a little at the risk of becoming a touch boring. However, I will seek to avoid slipping into long-winded legal speak. In summary, though, following my tenure on the bench of the Wardens Court since October 2021, which I have to say is one of the longer tenures within the Wardens Court since Warden O'Sullivan sat as the warden, because there's been a bit of a revolving door since then, I've actually formed the view that there was a troubling lack of information and knowledge about the operation of the court generally and its surrounding context. Now, that was surprising to me, particularly given, the mining industries in the state contribute a not insignificant amount in terms of the financial resources of the state, which are then available. And so it's somewhat surprising to me that people don't really understand what the Wardens Court actually does and how it operates and how it interacts with the industry in question. Now, it's also important for me to talk to you about what I and my colleagues, at the moment it's Warden Morn, prior to that it was Warden Cleary, have done, why that's important and why we're moving the court in a particular direction. Now, those were reform processes which were commenced by myself and learned Warden Cleary, as Her Honour then was, and they are meaningful. I believe that they will yield very significant results for both industry and the state and the administration of the Mining Act in Western Australia generally. Now, in my discussions with the chair, I did ask whether there are any matters the organisation would like me to address. And as Donna has indicated, my understanding was that there was a query that went out and some responses which came. I have to say, I'm not surprised by the responses that came. I'm gratified to see that, the sort of questions that I thought would be asked were in fact asked. And it confirmed for me the notion that this was a group of people who was probably quite interested in the sorts of things that I might be able to say about various matters. I've indicated to you that I've got some limitations about what I can say, but, I am comfortable expressing certain views, and the views that I am very comfortable expressing, you're not going to be surprised, are the views that I've publicly expressed in relation to decisions that I've made. And so I'm quite happy to talk about the nature of those decisions that I've made and the context of them and what they mean. Now, I have to apologise. John has indicated I don't have a PowerPoint. There is a very nice picture of a tree there, with, that calming and pleasant sort of visage. I have to say I'm not someone who uses PowerPoints. I'm afraid I'm regrettably old-fashioned in that respect, and I do apologise. And in relation to my presentation generally, I have to confess that when my colleague and dear friend Warden Cleary left my court in February this year, Her Honour was sent over the road to the District Court for her sins as a judge. Unfortunately, my workload has increased quite significantly over the course of the last 2 months, and so I will apologise if there's a bit of disjunct in the nature of my remarks, because I haven't had quite as long as I'd hoped to refine them in a way, but hopefully they make sense and are of some interest to the nature of the audience here. Now, in order to approach the questions that I've been asked, and for those of you in the room who asked those questions, you all know what they are, but unsurprisingly, they relate to Section 58, they relate to Forrest and Wilson, they relate to a range of other things like that in the context of what the decisions mean that have been made in respect of that area. Now, in order to understand the views that I will express about those matters, I think it's important to ask, first of all, the question of why do we regulate the mining industry at all? Which is, you know, the sort of basic starting point in relation to it. I think there can be no doubt that one of the most strident of criticisms that is levelled at those involved in some way in the regulation of the mining industry is the perceived over-regulation and what might be seen as excessive red tape and bureaucratic nonsense that appears to operate as a brake on investment and mining operations. Given my role, I'm obviously a part of that regulation, though, of course, I do not have any views on what that regulation should actually be. And if you'll forgive me, at this point, I'll depart from the dry world of the law and mining law momentarily in an effort to illustrate the nature of the message that I have in this respect. I'm going to refer to the crayfishing industry as a counterpoint. As a West Australian born, the fact of the crayfishing industry is something that's close to my heart because I love eating crayfish. And I'd ask you to bear with me as I seek to explain what it has to do with my discussion this evening. I expect I can say with a degree of comfort that it is known within Western Australia in particular that the rock lobster industry is a highly regulated one. Participants in the crayfishing industry are known to be subject to some quite draconian regulation, which is imposed in what I understand is a largely successful effort to ensure the sustainability and long-term survival of that particular industry. Indeed, the penalties for breaches of regulations in that industry include the very severe, the loss of pots, the loss of boats, the loss of licences, which of course equates the effective loss of livelihood of those concerned. No one, at least as far as I'm aware, agitates vociferously against the regulation of the crayfishing industry in that manner. And so my rhetorical question to you is this, at least the first of several. Given the crayfish can reproduce and thus be entirely sustainable as an industry, if managed successfully, why ought the mining industry not be managed in a similar fashion? After all, once the minerals are out of the ground, they're gone. At this point, I will also say that fact that the minerals once extracted are gone points to an actual reason to regulate the extraction industry, at least to a degree, in the hypothetical sense. There is a divergence of interest between the extraction industry and the state, which is required to be managed. For example, I don't think that anyone would sensibly suggest that mineral royalties should be abolished altogether. I don't think anyone's so bold as to suggest that. That is because there must be a recognition that minerals have value to the state as an entity, and the extraction of them results in a transfer of that value to the party extracting them. That requires a balancing of the interests in question, hence the need for regulation. That is not to say, I hasten to add, that the industry ought to be regulated beyond the necessary point to ensure a coherent balancing of the various competing interests. However, I would make the point that regulation in general is not something that should be regarded as a heresy, but rather the relevant question is how much and how is it managed? In terms of how it's managed, I'm now going to make some further comments about the rule of law and the role of judicial officers, which are important to understand the nature of the subsequent comments I have about the specific questions that were asked. It's very lawyerly of me, I know. My apologies. It's been a long day. The rule of law. The phrase the rule of law is a very interesting one, at least for me. Relevantly for our discussion, a good definition of the rule of law that has near universal acceptance in academic circles states that most of the content of the rule of law can be summed up in 2 points. The first is this, that people, including one should add the government, should be ruled by the law and obey it. And 2, that the law should be such that people will be able, and one should add willing, to be guided by it. If I was to expand on those guiding principles in more detail, I would suggest that all people should be ruled by just laws subject to the following principles. And I'll speak to them and make a couple of comments about each. The first and probably most important is that no one is above the law. It's a simple and trite proposition, but one which we see alarming challenges to from time to time. The anecdote I'll use is, and I would wager there's probably not too many people in the room who follow the travails of the Supreme Court in America from time to time. But one of the very interesting things that's happened this week is that former President Trump has in fact filed a set of submissions in a Supreme Court matter. The Supreme Court in America is the highest court in the land, which will make very serious determinations, much like our High Court. Now, President Trump has filed some submissions which in effect declare that he is immune from any kind of sanction at the time that he was president. He is seeking the Supreme Court to make an order that he was, when he was president, effectively above the law, and that the law does not apply to him. Now, I, as a lawyer who believes in the rule of law, think that that's absolutely crazy. But that's a matter that's going to be argued before the Supreme Court in America, and the judges there will make a decision. Now, just think about that in the context of what might happen in America if there is an individual in the White House who is above the law. In effect, the net effect of that decision, if it is made in the way that former President Trump is asking, is that he could murder his staff member in the White House, in the Oval Office, in view of other people, and never be prosecuted. Now, I'm not sure that's a good thing. The second principle is this: the rule of law must be supported by informed and active citizens. In this modern age that we live in of ill-considered comment, this is a very serious problem. Hence my view as to the desirability of addressing you and others. I consider that those of us who are in the judiciary really have an obligation to communicate, to inform as to the nature of the decisions that are made, because the prevalence of social media and other commentary exists to the extent that people who don't understand the nature of the technicalities of the work that's undertaken or the details of the separation of powers feel nonetheless perfectly capable of offering an opinion, of voicing outrage about the nature of things that I and other people do. And so it is important for us to communicate, be transparent and clear. The next point is this: the law is applied equally and fairly. There is one rule of law. It does not operate differently for different industries or different people. The next one is that the law is known and is accessible. Now, I'll talk about the plain and ordinary meaning of legislation later on when we're talking about Section 58. Again, it becomes a question of transparency. You as individuals, as part of this society, should be able to have an understanding of what the law is and how it's going to be applied. It shouldn't be a mystery. It should be very clear or easily ascertainable. The next one that underpins the rule of law is not really relevant to our discussion tonight: the presumption of innocence. Everybody knows what that's about. The one that is important, though, to our discussion is this: an open, independent and impartial judiciary. We, as judicial officers, are and have to be seen to be independent from external influences. I'll talk about that more in some more detail later on. The next one relates to a specific question that I was asked about Forrest and Wilson, and it's that, as a general principle under the rule of law, retrospective laws ought not be passed. Now, the reason why retrospective laws ought not be passed is that they are fundamentally unfair to someone. Now, it may not be the party that is advocating for them to be passed that it's unfair to, probably very unlikely, but they are unfair to someone. And so we don't do that. We don't move the goalposts, because moving the goalposts is fundamentally unfair to the people who complied with where the goalposts were. The next one is that the laws are made in an open and transparent way by the people. And I'll speak to the primacy of Parliament. I've already indicated I don't have a view as to what the law should be, and that's because the people down the road do that. The Parliament writes the law. Parliament has been primary in our system of government since the English Civil War ended in 1651 and the restoration of Charles II in 1660. Now, since that point, Parliament is the body that writes the laws, not anybody else, it's them. And Parliament is the representative of the people. And so the law springs directly from the people. The next one is relatively straightforward. People can only be punished in accordance with the law. That protects us from capricious decision-making by individuals who might exercise power over you in an unfair way. You can't think of anything more unfair than to be punished for something that's not a law. The next one is that government agents should behave as model litigants. They should behave perfectly. Now, that's honoured in the breach in most places that I've seen, and certainly in relation to the Department of Mines. From time to time, they behave in a way which is quite difficult to understand. The next is fair and prompt trials. Classical idiom of the law is that justice delayed is justice denied. A lengthy delay means that things don't happen. in the context of the work that you do in the civil space, in the mining industry, if you're waiting for years for an approval, then there's a year's worth of mining work that's not done, years worth of royalties that are not paid, rent not paid, expenditure not carried out, and so on. We must deal with things efficiently and quickly. Now, the next one relates to, and I'm almost at the end of my list, the separation of powers between the legislative, the executive, and the judiciary. I'll pause at this juncture and share an anecdote. I'll not name names because there's an individual in the room who I know. But at one point last year, I was involved in some quite difficult arguments, and one of the lawyers that regularly appears in front of me got up and said to me, in broad terms, you should do what the department has indicated is the view that should be expressed. It was in relation to a complex issue about it arose from Forrest and Wilson, actually, and they put up an email that had a piece of media attached to it that somebody from the department had said something, and as a result, I should therefore do what the department had indicated, and said to me that I was a delegate of the minister in my role as the warden. And I'll just give you a free bit of advice, and that is that if you go before a judicial officer and call them a delegate of anyone or subordinate to anyone, there really isn't a way to, more quickly irritate a judicial officer. I don't think you could do anything. For me personally, I don't think you could upset me more than coming along and saying that I should just do what somebody else does. My commission came from Her Majesty. I swore an oath to apply the law without fear or favour, irrespective of who it is. Now, I don't care what the department says. I don't care what the minister says in relation to the law. Now, if it lines up, great. But my obligation is to apply the law, and that's because the judiciary is separate from the executive, and the executive is separate from Parliament. You have to maintain those separation of powers, or else the entire structure of government starts to erode and fall apart. Again, I'll point to what's happening in America at the moment. There is an absolute train wreck occurring in Congress. They can't do anything because they are paralysed, and the legislative arm of government in America appears to be paralysed by its adherence to this possibly to-be executive that's coming in. And it's not a system of government that can work. Now, the last point to make is this, is that the law and the administration of the law is subject to open and free criticism. I've already spoken about transparency. And I'll say this again, all the decisions I've made that are in any way moderately serious have been accompanied by detailed reasons. Now, you can go and read them. I'm not sure you'd really want to, but, perhaps if you're having trouble sleeping, you might start at the first decision I published and work your way through. But they're all there, and you are welcome to write or say or do anything you like about them. I don't. You certainly won't be punished by me for offering a critique of decisions that I've made. The very reason why I publish those decisions and give those reasons is so that people like yourselves and others can actually look at them and say, no, he's made a mess of this. It needs to go somewhere else, or we need to do something else. And that way you participate in the development of the law. But I'm not making secret decisions behind closed doors. The reason why I do things is there for all to see. Now, as I've sort of indicated, although I probably missed the mark, without wishing to turn the discussion into too much of a civic seminar, most relevantly for the purposes of my comments is to state that my role as the warden in the administration of the Mining Act is plainly as a member of the judiciary. Now, there's some complexity in relation to the nature of whether I sit judicially or administratively, but the best way to think about it is that I'm a judicial officer and I operate impartially and independently from all other extraneous influences. As I've indicated, I'm independent from the government of the day. I have no role in the drafting of legislation, nor in the implementation of policy positions. My function is to seek to apply the law in a frank and open way without fear or favour to all those who appear before me. And those principles are dear to my heart and underpin much of my subsequent comments at this event this evening. Now, I've mentioned earlier my belief in transparency. I mentioned that it is easy to be transparent in the fact of a decision. As I've indicated, I can state a decision in a sentence. Explaining that process of reasoning, though, is far more difficult and, paradoxically, far more important. The conclusion in this respect matters less than the process of reasoning which led me to that conclusion. Now, the process, and the reason why that's so, is that the process explains the reason. that reveals the error of principle, if indeed there is one. Then it can be fixed. So if I've made a mistake, there's lots of discussion about Section 58 and the Zero Minerals and all the other cases that have been decided about that. If I've made a mistake about that, it's there. Somebody can do something about it. I haven't hidden it. You know what I've said. You understand why I've said it. You might think I'm wrong, huzzah, but, it's not secret. Now, as I've indicated, in the context and touching on that Section 58 issue again, one of the questions often asked of me now, particularly by my friends from the legal industry, my mates at university who tend to work in law firms now dealing with mining, so why did you make that decision? And the answer I give them is very simple. Well, did you read the decision? And usually they say, no, I haven't. And I say, well, here it is, have a read, and then you can understand why I made that decision. I don't have anything further to say about it really than that. If you're in doubt about the nature of the reasons that I came to the view that I did, the starting point is to read the decision. Now, those decisions, as I say, accompany, or all the decisions that I make are accompanied by those sorts of reasons where I set out how I get to the conclusion reached. And that's part of the rule of law, in the sense that I, as a decision maker who has a reasonable set of responsibilities to make decisions which impact a wide range of people, need to be able to explain the nature of the decisions that I make. And they're accessible to everybody, and everybody can look at them and think about them, and so on. And the operation of the legal system that we have is designed in that way to identify errors that might be made. It's on show and can be reviewed, appealed and corrected or changed by Parliament if they see fit. Now, as a further illustration of why I generally believe in these concepts, and I'm labouring them because, as I say, they go a long way to explaining the nature of the positions that I take in relation to Section 58, Forest and Wilson, and various other compliance issues that are directly relevant to the work that's done. I'll ask you another rhetorical question, and it's one I used to ask university students when I was teaching law at various places, and it's this. I want you to presume you find yourself accused of murder, but in fact you're innocent. But you look guilty. Metaphorically, you've been found in the bedroom covered in blood, spouse is on the bed dead, and there's nobody else in the room. That's what it looks like. And so in the court of public opinion, you've got some problems. The Twitter and the social media is very excited about how guilty you are, lots of commentary about it and everything else. But the reality, the position for this hypothetical is that you are literally like Harrison Ford in The Fugitive. Think the one-armed man. You didn't do it. Somebody else did, but nobody believes you. Now, the question is this, the hypothetical question, with that scenario in mind, can you think of many countries where you'd be content to be tried for that murder with a fair degree of comfort that you were going to get a fair hearing? Where would you be happy to be tried for that murder? I can't think of more than 5, really, if you think carefully about it. Would you be happy to be tried for murder in America? No. They elect their judges there. That's a terrible idea. If you really think about it hard, you probably settle with Australia, New Zealand, Canada, the United Kingdom, Ireland, and then it starts to get a bit thin. Maybe the Scandinavian countries. Maybe. That's about it, Now, in this respect, the rule of law keeps us safe in our beds at night from capricious decisions of those in power. I think that's rather important, particularly given the state of the world as it is today. And make no mistake, the fundamental principles that underpin the broad freedoms and safety that we enjoy in this country in answer to that hypothetical question are equally applicable to the regulation of the mining industry. There is one rule of law for all underneath it. Now, there's 2 further aspects I want to touch upon before I move to the specifics. The first is to refer briefly to the hierarchy of the court system in Western Australia. I do so because it relates squarely to the relevant discussions about Section 58 and Forest and Wilson. It's important to note that there is effectively no democracy in the court hierarchy system. I sit or swing around on the lowest possible branch of the judicial tree. For those not familiar with the operation of the law in general terms, that means that I'm bound to follow the decisions of those in superior courts. It's not a question of choice. I am compelled to follow the decisions of the Supreme Court, compelled to follow the decisions of the Court of Appeal, and compelled, certainly, to follow the decisions of the High Court. If a superior court speaks on a question of law, I'm bound by it. And to a large extent, that is what occurred in respect of the Section 58 decisions, both Her Honour Warden Cleary and I considered that we were bound by Justice Allinson of the Supreme Court in his decision in Golden Pig. Now, there are those who disagree with our analysis of that, but ultimately that's the view that we expressed. Now, the other thing I want to mention is this, is that I can only decide the case that's in front of me. It may come as a surprise, but I don't sit in my chambers and sally forth from time to time to dispense decisions on a whim in respect of matters I find interesting. Rather, my responsibility is to quell disputes that are brought to me for decision. My role is to resolve those disputes between parties that cannot be resolved themselves. As an aside, that fact might be borne in mind when considering the contentious aspects of my and other judicial officers, indeed, decisions. Always remember that a decision that is made by me or anyone else in the judiciary is a decision that's been made following one of the parties turning up and saying, Your Honour, this is what you should say. So it's not an exercise in us making it up. Somebody has come along and said to us, this is what the law should be. Now, another aspect is that as the Warden of Mines, I sort of indicated there's a bit of complexity about whether I sit judicially or administratively. Don't wish to bore you with the distinction between the two, but relevantly, as the Warden of Mines dealing with objections and tenure applications, I sit administratively, which means my decisions are not judicial, which means they are not binding, amongst other things. I can't bind anyone else. I can't bind a fellow warden. I can't bind the department. My statements as to what I consider the law to be are properly characterised legally as statements, pardon me, as to the limit of my jurisdiction in the case before me. Now, the last matter I wish to mention in this section of my talk is an extension of that last point. Whilst I cannot bind other wardens, and this is a moderately controversial thing that I'll say, however, I've said it half a dozen times in various decisions of mine already, so it shouldn't come as a surprise to those who do follow my decisions. I am a firm believer in the consistency of administrative decisions. I'm of the view, which I've expressed, as I said, in a number of cases, that there is a degree of benefit in people in like circumstances, so people like yourselves, in like circumstances receiving like treatment. So if one of you gets dealt with in a particular way pursuant to a mining application, an application for an exploration licence, I think it's not unreasonable that somebody else be treated in that same way, all things being equal. Now, in short terms, I strive to be predictable so that people like yourselves can take advice from practitioners and they can give it with a fair degree of confidence that it will be, in broad terms, correct, at least in respect of the practice of the law as I perceive it to be. My views on a range of matters in relation to the administration of the Mining Act are there for all to see. Her Honour Warden Cleary and I, in an exercise of enthusiasm over the course of the last 18 months or so, published about 100 decisions in relation to disputes in respect of the Mining Act. Now, if you go through those 100 decisions, as I said, not something I do voluntarily, but anyway, if you do go through it though, what you'll find is that we have spoken to a pretty significant amount of the issues in dispute in the mining industry in Western Australia. 100 decisions is quite a lot of disputes to have decided. We've covered quite a lot of ground in terms of the things that happen in Part 4 of the Mining Act and various other bits and pieces. Now, again, this is moderately controversial in terms of consistency of decision-making, but subject to intervention by the Supreme Court, it is difficult for me to see how, when or why I might depart from my previous reasons on a particular matter where I have said something specific about the way that the law should operate. I'm not inclined to change my mind in respect of questions like that. Now, my own view is that that's a good thing because it means that people in the industry have a degree of comfort that if they take a case to me, if they bring a case to me for a determination, there's a pretty reasonable idea as to what's going to happen, because then you can get legal advice. Now, it might be a hopeless case, then your lawyer can say to you, you don't want to do that because that guy up there, he's going to chop your application because of this reason. And we know that because he's made that decision in respect of this very same question, last year or something like that. Now, that leads me, finally, to speak about the Wardens Court and as an instrument of that regulation and part of the machinery of the rule of law. Donna, I don't have a clock. Can you give me the treatment when it's time?
Yeah, probably 5 more minutes and then we have to do some questions.
Oh, do we? Okay. Oh, well, that's disappointing. I had lots to go. I tell you what, we'll do it in brief. The first point I want to make is this. When I took over in the Wardens Court, they brought me 8 suitcases full of paper as the basis of the case list that I was about to do the following Friday. 8 suitcases full of paper. This is in 2021 after COVID. And I was shocked by that. I thought to myself, how can this possibly be? How can we have a situation in this state with a key industry of the state regulated by paper-based files? And the situation is worse because the Wardens Court was done across the state by magistrates. And the important thing to understand, though, is that they weren't magistrates sitting as wardens, just as wardens. They were magistrates sitting in the regions doing 100 criminal matters before having half an hour to do the wardens list in that space. And so the reality of the position is that those persons in those positions simply didn't have the capacity and the time to work in that space in the way that they needed to. And so as part of a set of reforms, Warden Cleary and I took a view that, well, this has to change. We're not doing paper and we're going to have all of the work done by 2 dedicated wardens. And that was done to enable us to have visibility over the whole of the jurisdiction. And that was important because when we did it, what we discovered was that there was different law being applied in different parts of the state. And so you could go to Kalgoorlie in respect of a ballot and have a different set of rules applied to you than if you went to Karratha and had a ballot. Now, there's only one law, and so somebody's doing it wrong. And the reason why this was happening was because we had paper-based files, wardens in the regions, and nobody talking to each other. Now, as a result of that, the reform work that we've undertaken was, first of all, as I've said, to digitise the court, which means that I now have access to all of the information that's relevant to the disputes that are in front of me, rather than simply what the department wanted to show me. So I can see everything, not just what they decide I should see. And furthermore, to consolidate the jurisdiction to ensure that effort in consistency of decision-making. Now, one of the questions, I'll deal with the questions over the course of the next 5 minutes. One of the questions I received was this. Previously, there were several mining wardens. Over the last year, it's reduced to 1. So even simple things that used to take a few days or weeks are now taking a month or more, withdrawal of caveats. Question, how are objections going to be managed quickly with only 1 warden? There's 2 wardens, so the premise is a little bit wrong. I understand why people think there's 1 because Warden Cleary's gone to greener pastures, but the situation is that there's 2. Warden Morn and I are sitting in the court. In relation to the specific question about the nature of caveats, I'm surprised by that question because the workflow that we have at the moment is such that work comes to me from demurs, be it caveats, mortgages, you name it, extensions of time. It gets distributed into a bunch of files that I then action. Now, there is nothing in my work files. Like, I empty those every day. And so the turnaround time for a caveat from me is about 24 hours. So if there are issues in terms of works or pieces of work going missing, that's interesting to me because I don't know where the bottleneck is. And so what I would ask, if there are such things, is that perhaps the organisation can write to the Chief Magistrate to bring those to my attention. So if there are caveats or things lurking in cupboards in various places in Western Australia, which happens, you know, I went to Southern Cross and it was interesting. You know, there was things in the cupboard that have been there for many years and it shouldn't happen, but it does. But we need to go and find those things. We need to open the cupboards, pull them out and deal with them. In terms of the other part of the question about how are we going to deal with objections, how do we know that we're going to be able to deal with objections relatively promptly? Well, I have to say this, and I'll be very direct about this, is that when I started in 2021, you couldn't get a trial for a year because the court was booked solid. Now, if you said to me, can I have a trial next week? I would say yes. Okay. Warden Cleary and I cleared the backlog of cases over the course of the last 18 months, and we have to now bully people to move their applications forward. I have lawyers who appear in front of me every single week. There's one's got a whole bunch of them coming on Friday. We'd like another 3 months to negotiate. And so the delays in relation to the resolution of objections are not with me and not with my colleague and not with the court. They are with the parties who don't wish matters to move in that fashion. As I said, I say again, if you want a trial next week, come on down. I've got space. Now, I'll just briefly mention the future reforms of the Wardens Court. We are moving forward in the space of adopting, we're going to look to adopt a case management system which should further create efficiencies for people like yourselves who are dealing with the court. You know, in the fullness of time, we hope to have a situation where there's a portal which will then empower you to input documentation into the system, sort of like EMITS, and then it comes to me for decisions without correspondence going back and forth and various other things. Now, the one thing I'll say is that in the context of the Wardens Court, regrettably, because the Wardens Court is created under the Mining Act, it's a creature of demers, and every other court in Western Australia is a creature of the Department of Justice. And for reasons that are not clear to me, demers and justice, they don't get along particularly well. And so there's some trouble in that space. And what it's meant in broad terms is that we didn't get the resources that we need. Now, since the appointment of the second permanent warden, we are moving into a space now where we are fighting hard to ensure that the court has the resources that are necessary to meet its obligations. Now, what's my next question? Okay. As you've been at the court for long enough, what are you noticing of the challenging circumstances explorers are encountering? Well, it's not it's not going to come as a surprise to anyone that compliance is a major problem. You know, compliance with the Act and the need for strict compliance is something that happened in 2017, and it changed the way that the mining industry operated in Western Australia. And that is a problem, particularly for explorers, junior explorers, and people who are doing a lot of the work themselves and not taking advice. And so what I would say to all people involved in the industry, and in particular tenement agents and solicitors, is if you keep track of the decisions that have been made, we speak about questions of compliance. A really good example of that is a decision I made in a case called Hawker, where I was talking about marking out and trenches and pegs. And there's a dispute about whether or not it was properly marked out because there was a gap between the post and the beginning of the trench. Now, you can't have unbroken ground between the post and the trench. That's what His Honour Justice Toddle effectively has found. I've applied that law. Now, if you go and get advice about what do I need to do to ensure my marking out is compliant, the person who gives you that advice should refer to that case because there's pictures in it. You know, there were pictures before me. I said, well, there's a gap and that's it, you're done. You know, so the law there is clear, but people aren't taking that step to actually investigate it before they do the marking out. And that has arisen really as a result of the change in the law. Now, in relation to, I'll just briefly mention another challenge, you know, one of the things that I see are tenement applications used in a manner which is inconsistent with the objects of the Act. A tenement application should be an application to go on the ground and explore, or go on the ground and mine, or use a tenement in a way to assist a mine. And there's lots and lots of things that happen, and I'm sure you all know about it, that are people who have never any intention of mining. One of my favourite cases I did, one of my very early ones, I had a chap in the witness box who, you know, in fairness to him, he was telling the truth, and he was asked some questions. He said, oh, I'm not going to mine. I don't mine on any of my tenements. And they were long, thin tenements. And he was taking them out around other people's mines and then saying, well, that's my tenement, so you've got to pay me some money to come across it. You know, and that's an abuse. And I threw him out. Now, the point I want to make to you is this: where you see things like that, it's on you to bring them to me. I have 6,500 disputes in my court. I can't go and police it. That's on you. It's the competitive tension that exists. If you see ground that you want to make open, then run an application for forfeiture and we'll see what happens. Now, I'll move to the bellwether topic. There have been some questions relating to Section 58. It's an understatement of the year. Statements for exploration licence applications under the Mining Act, which must propose a work program and budget for the full 5-year term, whereas in the past, many applications just stated 1 year of work program and budget. You apparently determined a case with this type of question in Azure Minerals Limited and D&G Geraghty. Can you describe the implications of that to the tenement managers for clarification? Deeply topical issue. As I've said, I said what I said in Azure. The reasons are there. Now, I'm happy just to expand briefly on the nature of the exercise. It's an exercise in statutory construction. Now, there's a set of rules that I have to follow when I try and decide what a piece of the Act means. Now, Section 58(1)(b) of the Act does not refer to a 1-year plan. It does not refer to a 5-year plan. Doesn't refer to either. It would have been helpful if it had referred to one of the two, but it doesn't. What it does do, though, is refer to the fact of the licence which is granted. Section 61 of the Act says the licence is granted for 5 years. Now, it also refers to the area. Now, the area is the area applied for. And so, applying the rules of statutory construction, I came to a view in good faith that it meant for the life of the licence and the whole of the licence. That's the view that I expressed. Now, I can't give you advice, but if you take advice, it will be, well, you should probably be compliant with what they say the law is, because they're the ones who are going to deal with your application if it is objected to. Now, I will say that question is before the Supreme Court. And I understand there's going to be a hearing in June on that matter. So my last decision, which was Richmond number 2, was finally the subject of an appeal. And so the Supreme Court will deal with that matter. And then we will hopefully have clarity on the issue, which will be great. One of the things that people ask me, which I will just mention, is how do I feel about appeals from my decisions? And I'll tell you this, I feel great about appeals from my decisions. And I feel great for 2 reasons. The first is it creates binding precedent. I mentioned precedent before. And if there is a binding precedent on a question where there hasn't been binding precedent before, it makes my life significantly easier because I don't have to answer that question anymore because it's been answered for me. The second reason why I want to say that it's a good thing to be appealed and reviewed in such a way is that it's part of the operation of law. The learned Chief Justice of the State made a speech recently where he spoke about the possibility of being wrong. And as I've indicated to you, thank you very much. As I've indicated to you, the rule of law requires people like me to make decisions. I have to make decisions in a room with lawyers on both sides where they both are absolutely convinced they're right. And in this jurisdiction, usually there's lots of money, there's very fancy lawyers, there's silk involved, and they're really convincing. You know, they stand there. I listen to one of them and I'm like, you're probably right. And then I listen to the other one and I'm like, you're probably right too. You know, but I've got to choose. I've got to make a choice between who's right. That's my job. And it's a lonely responsibility in the sense that I have to make that choice. I have to impose a decision on those parties. And the important thing to note is that to achieve the possibility of being correct, I have to embrace the possibility of being wrong. And as a participant in the nature of the industry and a participant in the judiciary, I have to accept that the decisions I make will be reviewed. And that's a good thing. And so it is a good thing. I encourage people to review decisions that they don't like that I have made. Now, as I've indicated, how Section 58 plays out, well, we'll see in June or July. One of the follow-up questions that came in relation to Section 58 related to the news that the department has been granting applications with 1-year plans where there's not been an objection. Now, nobody's actually told me that formally, but I inferred that that was the case. And the question is, well, isn't that a bad thing? And the answer is yes. It is a terrible outcome that the department is actioning applications for exploration licences in a manner which is inconsistent with the way that we are dealing with them in the Wardens Court. It's awful. It's an inconsistency in the application of the law, and it's not sustainable. And it's plainly not sustainable because either I'm wrong and they're right, or they're wrong and I'm right, or we're both wrong and there's some other way. Now, in any case, there's not 2 different ways it can be done. And so it's not a good outcome. How has it happened? Well, in fairness to the members of the department, they're in a position where they have to consider my decisions, which are not binding on them. So they're not compelled to follow my decisions. It's just a question of whether I'm right or wrong. There's many, many decisions that they've made consistent with the policy that they're now applying. I would expect that they probably took the view, this will be appealed at some point pretty soon. We'll just be consistent with the decisions we've made previously. Nobody appealed it for 18 months. And so now we have 18 months worth of decisions which have been made, which are potentially wrong, which is not a good thing. There's going to be some consequential questions, I expect, which follow. And I will confess in this forum that there is a tiny, tiny little part of me that actually genuinely hopes that I'm wrong in relation to the decisions that I've made, because it's a less traumatic outcome for the administration of law. If I'm right, if my reasoning in Richmond number 3 or Richmond number 2 and 3 and Azure Minerals is held up to be correct, then the same issue that we face in Forest and Wilson and the mining leases will apply to those exploration licenses which have been granted in the intervening period, which is not a great outcome. Which is why, lawyers probably are giving you advice to say, well, set your bar a bit higher, because then you're not at risk. Now, there was a question about diversification leases, which I can answer very briefly by saying I haven't had any diversification lease issues in front of me, but I would expect that they will be dealt with in the same way that pastoral leases are dealt with now. You have a balancing of interests, and then there's an assessment based on the evidence in respect of those interests as to what the appropriate course is. So I don't perceive that there's going to be a very significant disruption to the work of mineral explorers. The specific question related to renewable energy, what about people putting applications for diversification leases to build wind turbines in 15 years? Now, I think the answer to that, happy to express it, is that if something's happening in 15 years which doesn't relate to the minerals, I'm struggling to see why you wouldn't grant the tenure. That's something that should probably proceed. Now, before I come to the last question about Forest and Wilson, is there a view on being able to dismiss objections at the outset? For example, native title objections where they double dip in native title processes and objections by pastoralists when tenure is non-exclusive and there is already a code of conduct in place to protect pastoral activities, or even when there is no encroachment. Now, can you deal with those quicker? And the answer is yes, you absolutely can. Warden Cleary and I fear genuinely going to be remembered for our Section 58 determinations and, the bad things we've said to the mining industry. But I just want to draw your attention to a couple of decisions. There's a decision I wrote called AC Minerals and Kawana Downs, which was a decision involving a pastoralist where I basically said, well, you don't have a right of veto here. You can have an argument about conditions, but that's it. And as a result of that dispute, which might have taken years, only took a couple of months. And furthermore, my colleague Warden Cleary wrote a decision called Telupac, which was an environmental objection. So there was one of those delightful environmental objections, which as long as he ran from a whole group of people, it was general, non-specific. And Warden Cleary said, well, I'm just not going to hear it. You can deal with that in the NPA. Now, the relevant point is this: if you've got something that you think is an abusive process, you have to bring it to me, though. I'm not going to find it. You have to take advice, file an interlocutory application, come and see me and say, this can't proceed as an objection. It's hopeless. It needs to go. And then we'll see what happens. Now, the last point that I'll make, I think I've answered most of the questions. The last one that I've got on my list. For mining lease applications, I have to be very careful what I say here. I'll have a glass of water. Always a good tip for young advocates. Feeling nervous, have a glass of water. For the mining lease applications, DEMIRS have amended their policies to require the supporting documentation to be lodged at the same time as the application, referring to mineralisation reports. However, the issue remains about previously incorrectly granted leases and whether Forest applies retrospectively. Very helpfully, this still needs to be resolved. Yes, absolutely, it does need to be resolved. It would be great if it could be resolved. It would solve one of my major headaches. The issue is this, though. There is no question as to whether Forest and Wilson applies retrospectively. It does. Forest and Wilson is a decision of the High Court. It speaks very plainly as to what the requirements of an application for a mining lease are. If you don't comply with the requirements as set out in Forest and Wilson, you have no mining lease application. The High Court is not wrong about its application of the law. I can be wrong. I can be reviewed. I can be reviewed in a number of different places. The High Court is not wrong because it will not be reviewed. The circumstances where the High Court overrules itself are so rare as to be effectively non-existent. It's not going to happen. So the only change that's going to happen in respect of that particular issue is if there is a change in the legislation. And presumably everyone's aware of what happened in 2017. There was a kerfuffle following that decision. There were some concerns raised, and then representations were made in 2017 and 2018 that, look, it's fine, it'll be fixed by way of legislation. And a bill was put to Parliament in 2018 to fix the problem. I will note cheekily that that particular piece of legislation also included an amendment to Section 58, which then expressly said that Section 58 should refer to a single year of exploration budget So it would have fixed the Section 58 problem as well. It did not pass. Not only did it not pass, it's gone. It's fallen off the notice paper, which in parliamentary terms means it's just disappeared. It is not before Parliament. So there is no legislative fix for that issue before Parliament right now. Now, I can't speak to that because I'm not a member of Parliament, not the minister. That's an issue for them to deal with. The issue for me, though, obviously, is, well, what does that mean in the context of the law? Well, it means that Forrest and Wilson is good law in relation to the question of mining leases and their validity. Now, what the consequence of that to people who have mining leases which might be subject to a question mark as a result of that is a different issue. Now, it's a different and complex issue which has not yet been before me. What has been before me is a series of requests to delay the asking of that question indefinitely pending the arrival of the legislative fix. But there is no legislative fix. In a recent decision of mine, which I gave last week in relation to Section 58, because a question arose for me last week as well, there's a Supreme Court review that's going to be heard in June. Should I continue to apply the rules in Azure Minerals and Truefella pending the outcome of that review? And in the decision I made last week, which is a case called In the Matter of Electron Resources, I came to the view that no, it is not appropriate for me to apply the law in the shadow of the Supreme Court review, because I'm fairly certain that there will be a change in the law as a result of that decision, and it's appropriate for me to await the outcome of that case. The relevant point is this, and this is a quote from Justice Olney of the Court of Appeal, which in my view is determinative of the relevant question in the Electron decision. As a matter of constitutional principle, the judiciary must never allow itself to be placed in the position of being used as a tool of executive government. The ordinary processes of the courts must continue to be given effect to, notwithstanding any desire of the executive to the contrary, even when that desire is backed by the threat of parliamentary intervention. But this is not such a case. The executive seeks no consideration from the court to advance its own case. On the contrary, it has quite properly held itself aloof from the matter at present in issue. Although the legislative, judicial and executive branches of government perform their separate functions quite independently of one another, they do not exist in a vacuum. The ordinary processes of government cannot be ignored, and in the present context, it would be pedantic in the extreme to suggest that there is a strong probability amounting to an almost absolute certainty that within the near future, Parliament will validate the action of the minister which Wingate has challenged. The pertinent point is at the end, in Electron, I expressed the view that to delay the application of the law in any circumstances, there needs to be a strong probability amounting to an almost absolute certainty that within the near future, that the law will be changed. That's the view expressed by Justice Olney, which is binding upon me in all respects. Now, in relation to Forrest and Wilson, I can't tell you what the answer is because I haven't heard it yet, but the law's not unclear. And the question you have to ask yourself is there going to be a change in the law in the near future? Now, there's not going to be a change in the law from the court's perspective. So it's different from the case that I dealt with in respect of Section 58, because the Supreme Court's hearing it, in a couple of months. Nobody's hearing a challenge to the principles in Forrest and Wilson, because they can't. The High Court is very clear on the issue. So that leaves you with legislation. And as I said, the legislation disappeared in 2018. Now, I think my time might be up, Donna.
I might not let you off the stage just yet.
Okay. Thank you for your attention, though.